Good morning. Talking Law with Eugenia. I'm your host, Eugenia Matthews, and I am back again this week with my special guest, Henry James of Henry James Legal, 0414 414 520. Welcome again, Henry.
Thanks, Eugenia. Lovely to be back on the air with you.
And I really do appreciate you coming in, because this is an area of law, the employment part of it, that I don't do, but often it intersects with criminal matters that I have, for which you are assisting me on a couple. But I've had lots of queries about what happens when criminal law and employment law come into contact together, so that's why we're discussing this today. There are a few questions that were sent in, so we're going to talk about them today. The program is brought to you by Adelaide Hills Toyota, a proud Lofty sponsor. As always, we start with a song, one of my favourites, Linda Ronstadt, You're No Good. You're No Good, and that was a fantastic song. Talking Law with Eugenia. My special guest is Henry James. He will speak to you in a moment. As you know, we are going to discuss what happens when criminal law and employment law intersect. That usually happens, in my experience and my colleagues' experience, I must say, when you have the police turn up at your door, or they've contacted you in some way and said, we need to put some allegations to you, and those allegations are serious and then affect your employment. It might be your employer has reported to police. Whatever the case is, it doesn't really matter. We're talking about what happens when criminal law and employment law intersect. And I'm again introducing Henry James to you. Welcome, Henry. Shall we go straight to questions, or is there a blurb you want to do first?
Well, I think we can go straight into the questions, but what I'll say first is that obviously the intersection between the criminal law and employment is extremely important, because it's one thing to face criminal charges and the stress and the trauma that causes an individual, but when it also has a direct impact on your livelihood, your ability to earn money, even before the courts have reached a verdict as to the criminal charges, that can understandably be an extremely distressing process, where an employer makes moves to try and either put you on unpaid leave or in fact terminate your employment merely by virtue of you being subject to a criminal investigation, is something that I don't think is in most circumstances overly fair, but certainly something that I guess will be the focus of our discussion today, on how to navigate that if you're in that situation.
Exactly. Now, what I will say from the criminal law perspective, which is the area I do, if police turn up at your doorstep, for God's sake, do not answer any questions other than, my name is Eugenia Matthews, my date of birth is whatever, I live wherever, which is a bit silly because they know where you live. They've turned up at your house. Hopefully they've done it after hours and they haven't turned up at your workplace, although I have seen that happen.
Many
but whatever
times.
you do, do not answer any questions. Get a lawyer immediately. There are lawyers that will be able to assist you. If not, ring the Legal Services Commission, and that's all you do, and you make a time with the police to go to them later and answer a question. You will not be able to explain it away. Just don't speak to them. There are good reasons for that. Nothing you say can be used against you. And two, it will actually cheapen your defence, because if you're employed, you have to pay for it yourself, and we are a grudge purchase. I've never had clients come to me because they love me. They come to me, and I'm sure all of my colleagues, because there is a problem. And we are after tax money. So whatever you do, keep your mouth shut. You can't explain it away. And you will honestly cheapen your defence by saying nothing.
Well, absolutely, Eugenia. And as I've always said, there's nothing that you can say on your doorstep or on the side of the road that your solicitor can't put in a letter the next morning.
Exactly, after they've had a time to consider all the issues so that you don't get into trouble. Okay, this is a question, Henry, and it's I have been directed to make a false statement. I don't want to do it, and I'm being bullied at work. in the lunchroom, the person has overheard things like, well, if they don't do this, we'll call police. What should this person do?
That person should not do what they've been asked to do because it's unlawful. And you don't always have the protection of the fact that, oh, well, it was what my employers told me to do as a defence to a criminal charge. So if what they're getting you to do is illegal or potentially fraudulent, don't just assume that you have the protection of vicarious liability. If you've committed a crime in the course of your employment, you can still be criminally charged and often will be criminally charged. What you should do is you should refuse to do it, and really get onto a lawyer as soon as possible, because there's a number of issues there. First of which being that there could quite possibly be quite a serious psychological injury workers' compensation claim for the bullying, which I won't go into today, but we've covered in other shows. So there's possibly that issue. But also, for the purposes of today's discussion, you cannot allow yourself to be led into committing a criminal offence by your employer just because they're your employer.
Exactly, and my advice, because this is actually very similar to a case I'm very familiar with, whatever you do, don't go to HR on your own. Once it gets to the point where you're being asked to sign a false statement or an affidavit or whatever, you're in trouble. You're already in trouble. You've probably been subjected to bullying. You know where this is going to go. You will not be able to sort this out on your own. You should get some legal advice as soon as possible. And if you are also becoming ill because of this, so you go to work stressed, you can't sleep at night, you can't function in your private life, go to the doctor. And as I said, legal advice at this point is critical. You might need to leave that workplace, but do not commit that criminal offence. You will not have a defence.
And don't let the employer trick you into thinking that they'll cover for you either.
They
because
won't.
If they're willing to do something as despicable as get you to sign a statement that's untrue, you should have absolutely no confidence at all that they're going to have your back.
No, they won't have you back. And as awful as it is, and I ended up having to say to somebody, look, you might just have to leave that workplace. I know it's hard. I know you love this job, but you might have to retrain. But whatever you do, do not commit that criminal offence. You can ask them to put it in writing, which will probably inflame the situation a bit more, because then you'll have something to use against them. They've already started bullying you. Whatever you do, I know I'm a broken record. Go to your doctor, put this in writing, start a diary. Today, Saturday, the 23rd of September at 9 a.m, I was hauled into my supervisor's meeting. He or she said X, Y and Z. This is how I felt about it, and this is what I said.
Well, actually, one of the first things I advise people of is to go to their doctor straight away, because if they can get a certificate from the doctor that says that they're unfit for work because of psychological stress or bullying or whatever the case may be, that can often be used as a facility to actually pause the employer from making any moves to sack the worker. So if you can provide the worker with, as a solicitor, you provide the worker with a letter saying, my client will not be attending work this morning, here's a certificate from his or her doctor saying that they're unfit for work, they would not ordinarily be allowed to terminate that worker's employment because there is a reasonable excuse for them not being at work, being that they are genuinely unwell. Exactly. And then that can buy the worker a couple of days or so to really work out what their next moves are going to be. Exactly.
And if you get in first, they can't fire you. You'll be on work cover at least. I know you probably don't want to go down that path. All the phone calls and emails and texts I've had are saying, but I don't want to go on work cover. Where will I get a job again? The point is if you commit a criminal offence, you might well go to jail, Henry's right. If they want you to commit a criminal offence, they're not going to have you back. And no, they will not put it in writing. You need to protect yourself. And to that person, if you need to call me after the show, 0401 269 091, and I'll discuss this matter more because we need to move on to other questions. There's question number 2. I refused to participate in bullying. Now I've been accused of stealing from work. Now this is typical in my experience. I've seen this often.
It's definitely a difficult and uncomfortable situation. Again, it may be a trigger to commence some sort of workers' compensation claim and do what we did in the last question, which is remove yourself from the employment situation. But leaving those issues aside, say that the employer has now reported you to police, that can cause enormous problems for continuing on in that role, or effectively, if you are charged, you have to remember that it's only an allegation, that it doesn't mean that anything's proven, and if you really do believe that it's a false allegation, for whatever you do, don't think that pleading guilty early is the easy way out.
No, because if you plead guilty and you haven't done it, and I've known many people who have entered a guilty plea because they've been so sick by the end of it, they just want it to end. What happens next is you get fired for serious and willful misconduct. It's very difficult then to overturn something in the industrial court because you've entered a guilty plea.
Oh, absolutely. And pleading guilty to a criminal offence is the silver bullet for an employer getting rid of you. It's the whole reason why they levelled the allegation in the first place. If they secure a criminal conviction, they're home and hosed. There's nothing you can say on an unfair dismissal application to refute that.
No, I mean, the only thing I can think of, Henry, and you'll have to help me and the listeners out because, as we know, I don't do employment law. If they were to enter a guilty plea because they were so sick in and out of, let's say, a psychiatric facility because... And I've seen people who then try to commit suicide because the pressure's so bad. Yeah. Can they possibly fight it with some evidence from their psychiatrist that says they were so overborne by mental health illness, they entered that plea when they were not in their right mind?
Quite possibly.
I think it would be hard.
Quite possibly. It would be very hard. It certainly would be hard, but if you're in the position where you've been sacked and you've got no other options, you'd want to get straight onto it because there's very finite periods in which you can file a claim for unfair dismissal. I think you only get something like 2 or 3 weeks to put
21
days to put your notice in. So if you are going to do that, you need to move swiftly. But I guess though you might be clutching at straws at that point, what other options do you have?
It's a really awful situation. I remember in my life previous to law, and the questions I'm getting, unfortunately, are situations where in my previous job as a psychotherapist, these are all too common. And I can pick a client that I used to have on all of these scenarios, or at least on part of the scenarios.
I think it is awful, and I think when people are in those positions where us lawyers describe their situations as clutching at straws, that has to be a real indicator that you cannot let yourself get into that position. So don't succumb to the pressure of pleading guilty. Exactly.
Would it help, this is a question, would it help if the workplace that you were at, human resources, had many psychologists, industrial psychologists to come in and look at why that particular office was dysfunctional? Would that help if you were so overborne by mental illness you entered a guilty plea to something you couldn't do because you just couldn't take the stress anymore?
The problem in the criminal jurisdictions, Eugenia, is that if you plead guilty, you've thrown away any opportunity to come back and really unargue it. It's the bell that can't be unrung.
That's right.
Once you've pled guilty, that's you putting your hand up and saying, honest to God, I did this.
Exactly.
And it's very, very hard to wind that back.
And what your lawyer can't do is go to court and say, Your Honour, my client's entering a guilty plea, but they didn't do it. If you enter a guilty plea, you enter the guilty plea either on an agreed factual basis with prosecution, or you accept the entire allegations.
And I've observed magistrates refuse to enter the plea on that basis, where the person has to freely accept that they committed the offence in order for the guilty plea to go in. It's not I'm guilty, but it's I plead guilty to the charge.
Exactly. And you know what? I've seen these people, not only does it affect them, it often destroys their marriage. They're not able to raise their children because they're so ill. And this has repercussions down the line. Whatever you do, if you find yourself in this position, get some help immediately. You need it documented. At least keep a diary about what's happening, dates, times, where you were, who said what, how did you feel, that kind of stuff. If you want to, sure, go to HR the first time, but in my experience as an ex-psychotherapist and as a lawyer, what happens is the workplace becomes toxic. How dare you go and dob? We just don't dob in this country, but you have to protect yourself.
I always have my concerns about employees that go to the HR appointed psychologists, because one has to wonder who pays their bill.
Oh, I would never go to a psychologist appointed by HR. Don't do that. We get our own, because if you go to their psychiatrist and they are paying, let me assure you, in my experience, I've never seen one of the employer psychiatrists actually be independent. I was involved in a case in my psychotherapy days where the psychiatrist actually said at a meeting that I was present as a support person, oh, but you know he has a personality disorder. Now, that came from the employer. So how independent is this work psychiatrist when he or she was already saying, but you know they've got a personality disorder? They're not independent at all.
No, exactly.
And I've also been involved in a case where the psychiatrist gets some advice from their own family member who does law. And when asked in cross-examination in the industrial court, well, you know, why did you get that advice? Well, why didn't you put this to the client? Oh, I couldn't do that. They would just lie. They're not independent. They've made things up. Now, what we're going to do is we're going to go to a song, which is Copperhead Row by Steve Earle. And I hope you like it. When we come back, we'll continue with our questions. And that was Copperhead Row by Steve Earle. You're listening to Talking Law with Eugenia. I'm your host, Eugenia Matthews. The program is brought to you by Adelaide Hills Toyota, a proud Lofty sponsor. And again, we have Henry James of Henry James Legal, 0414 414 520. I almost forgot again. Oh, I'm terrible. We did have a chat through the break, and there was a question that came through. Can I be fired if I have a criminal conviction?
A question that I get with almost every criminal inquiry that comes through my doors, Eugenia. People are obviously very worried out there about their ability to meet the cost of living these days and what the effect of a criminal offence might have on them long term. Again, when we say think twice about pleading guilty in a hurry to get it over and done with, one has to wonder about the long-term effects of getting saddled with a criminal conviction.
Oh,
One of them can be the effect that it has on employment. Now, ordinarily, a person doesn't have an obligation to disclose their criminal record to their employer unless there's either a requirement in their employment contract that says that they are to do so, or whether they're in a profession that's governed by a professional body that requires disclosure. So, for example, Eugenia and myself, we can't go around and commit offences and then not tell the Law Society that we've got in trouble.
Oh, good God, no.
School teachers have to tell the Teachers Registration Board that they've got in trouble. Nurses have to tell the relevant medical body, as do doctors. So there's a number of professions where there's a statutory requirement to come clean about your criminal record. But if you're in a job where you're not saddled by that requirement, you could arguably get away with not having to tell your employer. And certainly I have situations where people come to me and they want to plead guilty after receiving proper diligent advice. And for example, in drink driving matters where letters of support are often a valuable thing to have as part of guilty plea submissions. A lot of the time I'll say to them, could we get a letter from your employer saying that you're a responsible individual and that you've been working hard for many years? A lot of the time people will say to me, I don't want to tell my employer, I'm deeply embarrassed and I'm worried about what they might do. So sometimes it is definitely wise, unless you have to, maybe it is diligent advice to keep things stum from your employer if you're not required to let them know.
I don't think they have a right to know unless it's a professional body where you have to disclose. Now, one thing I do like about the legal profession, unlike the public service and private enterprise, and I'm not particularly impressed with any of the governments really, but they quite often say to employers, you should hire someone that's got a conviction or they've done some time in prison. Give them a break. They've served their time. They shouldn't be punished twice. But you try getting a job in the public service with a criminal record, it's almost as rare as hen's teeth.
Yeah. And the sad reality of that, Eugenia, is in my experience, those that have gone through the system and have been charged criminally are the ones most desperate for a second chance, and when given one, are often the most grateful for having that second chance.
Exactly. So, if you wanted to do medicine with a criminal conviction, you're not going to get in. Nursing, teaching, all of the professions, you've got a lot to lose. And this is particularly so if you've been asked to commit a criminal act at work. Don't do it, because you're not going to be able to come back. You'll be fired for serious and willful misconduct. Now, your travel will be affected too.
Absolutely. To answer the other part of the question, can they actually fire you for having a criminal offence? That's not an easy question to answer, because there's many elements to it. And really, I think one of the most important issues is deciphering whether or not the criminal offence itself affects one's inherent ability to do the job.
Exactly.
So if, for example, you're a bus driver or a taxi driver and you wind up getting a 6-month disqualification for drink or drug driving, then absolutely I think it becomes untenable that you can't do your job if you're 6 months disqualified.
Exactly.
So they would have every reason to get rid of you for that. You are, from a legal perspective, unable to meet one of the basic requirements of that job. So it's effectively a breach of contract type argument that they would run, and they would have every reason to terminate your employment. On the flip side, if you were, say, a checkout operator down at the local Woolworths and you were done for 6 months disqualified of driving, but you're still able to get to your shifts because your mum can drop you off, or you can get a taxi, or you can take the bus, I don't think that it would be lawful at all for them to terminate your employment on that basis. Your private life doesn't always intertwine with your working life, and it is possible to have committed a criminal offence and be charged and convicted, and for it to have no effect on your ability to do your job at all. And in those circumstances, I think people should be allowed to keep their job.
Now, on a very controversial topic, and I'm sorry, listeners, but this actually happens often. If you work as a teacher or a nurse or in childcare and you've been accused of historical child sex abuse, and you're put on the register so that you can't do any child-related work, but you're obviously defending it. What happens to those people? Because it's really sad.
It is extremely sad, and it's really, in many respects, goes against the basic tenets of innocent until proven guilty. Now, I don't want the listeners to get the wrong idea. I don't advocate for people that are found guilty of committing those types of offences. I think the people that actually do those things against children are just unspeakably awful. But I do feel enormously for those that are falsely accused, and there are plenty of those out in our community. And the fact that the people that are falsely accused often find that they're judged before their time is just terrible.
I agree with you. We are not advocating for convicted pedophiles. We are talking about the ones who have been falsely accused, and this happens more often than you would believe. I know because I do this area of work just about all the time. For some reason, I'm either doing child sex offences, rapes, or serious drug trafficking matters these days, but people do, unfortunately, make up lies for whatever reason. And the person who is the subject of those allegations really needs to get legal advice. Whatever you do, do not speak to police. If you are put on the register and you're a primary school teacher, I remember when my kids were little, one of the teachers was charged for a child sex offence, and the teacher was innocent, and it was proven innocent.
But before that's proven innocent, they get turfed from their job.
She certainly was.
So they have no capacity to earn money, and therefore no capacity to fund their defence.
Exactly.
It becomes very difficult to afford to pay a lawyer when you are out of work.
No, she had to sell her house. Thankfully, she's back working, and not in that field, and that just about destroyed her because she, from a child, that was her dream to be a teacher, and it was taken. So they end up being bitter and twisted, and frankly, although that was using the vernacular, bitter and twisted, who can blame them? So be very careful. If you've got any any instinct at all that your employment is going to be threatened by some type of criminal allegation, immediately go see your doctor, immediately get legal advice.
But that is definitely a situation where you can't hide the conviction from the employer.
No.
There are mandatory notificating processes that are triggered by a person being charged with that type of offence. And even before charges are formally laid, where a person's even made the subject of inquiry, that can trigger notification of various registration boards.
Exactly.
And the issues can start from there. So my suggestion to anybody who finds themselves even receiving a whiff of the investigation is to immediately get advice, because things really spiral out of control pretty quick.
Exactly, and we know that when we have to renew our practicing certificates every year, there are show cause events ranging from you've been denied credit even in your personal capacity, you've got some kind of conviction, even if it's just a DUI, you still have to report that. So just take care. Look, we're going to go to a song. It's Little Lies by Fleetwood Mac. I like Fleetwood Mac, so enjoy it, and we'll come back and then we'll do a little bit more and conclude the show. Talking Law with Eugenia, the program is brought to you by Adelaide Hills Toyota. I'm your host, Eugenia Matthews. We're back on air, and I have Henry James of Henry James Legal assisting me today on the employment aspect. Welcome, Henry.
Oh, hi, Eugenia.
Do you want to tell them your number? Because
Yes, it's 0414 414 520.
Okay, we're continuing criminal law intersects with employment law. You've been investigated by police. They have laid charges. What you've been accused of is directly relevant to your employment, and you've got a show cause letter from your employer saying, please tell me why we shouldn't terminate your employment. What happens then, Henry?
I think you should get a lawyer to write it for you, because you get one go at it, is really the blunt advice I'd give anyone, that you're really probably only going to get one chance to keep your job. So get that letter written absolutely perfectly.
Exactly.
And if they say we want an answer in the next day, tell them that you need more time to get your lawyer. Don't succumb to the pressure of feeling like you have to respond to them immediately. Buy yourself a bit of time, get yourself someone who knows what they're doing and does this routinely, to really put together the best letter possible to really tackle the issue head on.
Exactly. I did an entire show about 6 to 8 weeks ago on show cause letters. Now, the reason you do that, as Henry said, is also because when you're writing it, you're emotionally involved. And quite often you'll put things in that aren't relevant, and the things that you leave out that are relevant won't be there.
And the things that you include, if you're charged with the offence and not yet convicted, might inadvertently play your hand and may not make you seem... You may think that you're trying to... It's a bit like explaining it to the police, right?
Exactly.
You might think that you're explaining your way out of it, when in fact what you're actually doing is burying yourself in the trouble more, by putting in too much information and inadvertently admitting to things that you are sure you didn't do.
Or even possibly giving them other avenues of investigating and possibly other charges. Whatever you do, you must get someone else to write it for you. Look, there are community legal centres. If you can't afford your own lawyer, the Legal Services Commission might be able to help you through their civil division, but you should get a lawyer. This will be the best money you've ever spent. If you're going to spend the money, even if it is a grudge purchase, this would be the one thing that would be worthwhile. It's an investment in your employability.
I'm sceptical of most HR processes, because I mean, really, a lot of them are box-ticking exercises so that the employer can't get sued for getting rid of you. They're not really there. They'll tell you it's there to help you and to assist you. It's really to assist them in not getting sued at the other end of it all when they sack you. So you need to go into any HR meeting with your eyes wide open. They are not there to assist you. They're there to cover their own backsides.
Exactly. Now, a question that I received just now is, I was called into an HR meeting. I was complaining about work not paying me correctly. They were not nice, and they were taking the mickey out of me, and they then said that I threatened them. And I didn't threaten them, and they've terminated my employment.
Well, that's unfair dismissal. So a person really needs to really get some very quick advice on unfair dismissal. You get 21 days to file that. After that, it's too late. So you need to get straight on to talking to someone about getting an unfair dismissal application up. If you are sure that you didn't do it, if these are allegations against you that aren't true, stand up for yourself.
Exactly. And what I have found is a good employment industrial lawyer like Henry will be able to assist you and take you through this. Whatever you do, you need some legal advice. If you then want to go and represent yourself, which I don't recommend. I've seen people in criminal court plead guilty to things they can never prove.
I've spoken to people that have represented themselves that wish they didn't.
Exactly. They end up with a conviction for something they didn't actually have to have. Yep. So, you know, if you're going to spend the money or borrow the money from friends, this would be the time. This is an investment in your life. The employer doesn't care. The business will go on without you. You're replaceable. I'm replaceable. Everyone's replaceable. When we were personnel, and this is my little soapbox thing, the focus was on people. Then we became HR, human resources, and that's really what they think of us as. We are just resources. We're a machine to do a job, and we're expendable. So don't think that your employer is going to have your back. They're going to cover their own selves, whatever happens, and you're going to be on your own. And you'll be surprised how your file disappears. It'll make its way to the shredder, fall behind the filing cabinet. Somehow it will be gone. They'll have your file for the police investigation, and miraculously, it seems to have disappeared. How often have we seen that?
Very.
Now, the final question I think we'll have time for is, you've been spoken to by police. They've decided to charge you. You've been placed on bail. And one of the bail conditions is that you have to be at home from, let's say, 7 p.m. to 5 a.m. in the morning, but they're your work times.
Right. You need to get a bail application submitted to vary your bail. That is something you could do yourself, but again, we've cautioned you against that. You could get a lawyer involved, and that's probably prudent. But what the court's going to need to see is they're going to need to see some evidence that you really are genuinely needed at work at those times. And if you can prove that you are going to be working and that you need the bail varied for the purposes of keeping your job, I think most fair-minded magistrates would be willing to grant that on certain conditions.
Exactly. And what happens if you've got a matter where there's some criminal stuff involved? So, for example, here's one. I'm getting bullied at work. It's unhealthy. I'm not well. Can I take out an intervention order or a restraining order? Can I get a restraining order against the bully? I'm worried for my safety.
In a general sense, yes, you can get a restraining order against anyone that makes you feel unsafe. However, whether that's going to cause you problems with keeping your job is not an easy thing to answer. I think if you're suffering bullying in the workplace that's that bad, you really need to be getting some urgent advice from someone who knows their way around workers' compensation and employment law issues, because that's an issue that needs to be tackled head on. If you're not feeling safe in the employment situation, there's something that's fundamentally gone wrong.
Absolutely. You shouldn't go to work feeling stressed before you even get there. And then there is the question, we got to do more than one or two, the question of, I drove the work car home and my employer has reported me to police for using the car without permission. What happens?
Well, what happens there is that you obviously, there'll be a strong desire in the mind of most employees that when the police pull them over, they're going to turn around and say, "Oh no, but the boss man said I could drive the car." For heaven's sakes, don't say anything.
No, don't say anything.
Keep quiet to the police. Wait until you were formally charged, get some advice at that point, and then look at negotiating the outcome through your lawyer as to whether it goes to trial or whether the charges can be withdrawn. But you want to really resist the temptation to try and explain your way out of it, even though you think there might be a reasonable explanation. Carrying on from that question, actually, I've just thought of an issue, Eugenia, that does affect some people. They're driving a work vehicle and they get pulled over for drink driving.
Exactly.
And the work vehicle becomes impounded.
That was a question that just came through.
Oh, there you go. Okay.
There we go.
So what can happen with the work vehicle? Well, this is a bit of advice for the employers out there. There is actually an ability to put an application into South Australian Police. This is an application that goes direct to police for the vehicle to be released early from the impound, because you're the owner of the vehicle and you're not the person that committed the offence. So that can be a useful facility not only for employers but also for girlfriends and partners and boyfriends and whatnot, where a mate's borrowed your car and they've managed to get it impounded. If it's your car and you're not the one that did the naughty business, you can make an urgent application to police to have your car released for the impound. One of the main reasons why you'd want to do that is that the impounding fees, by the time the matter goes to court, can often be in the realm of about $1,500 to $2,000 worth, and they will slug you with that bill. So
exactly.
you want to be acting swiftly to get your car back if some other muppet has taken your car and managed to get it impounded.
I had that very inquiry, but it was from a parent saying the police have taken my car, my child was driving, and they won't let me have my car back. And I said, is the car registered to you? He said, yes. And I said, well, I'd go back and say to them, take your proof that it's your car and say, I'd like to get my car.
It's a reasonably simple form. It's one of the few things that I would say a person's probably able to do themselves. But if you have any trouble, you can always give Eugenia or myself a call.
Yes, please do that. Now, last night at about 1:40, I got a phone call. Somebody was driving a car, can you believe it, 0.183.
How do they even get the key in the ignition at that level?
I've absolutely no idea, but they rang and they were at the police station and they wanted some advice. And thankfully, the person was so inebriated he couldn't actually answer anything, so that will be helpful for him. But if you're working, don't drink on the job. They can fire you for that.
Well, quite apart from the legal issues, I think Eugenia and I would be united in saying that no one should ever drink drive, quite apart from the fact that it can ruin your career, it can ruin your criminal record. It can also ruin your life. If you end up killing yourself or killing someone else on our roads because you were selfish enough to drive while intoxicated, that's got issues that are far more serious than even any of the legal issues that are at play.
Exactly. So what we want you to do is we want you to be safe on the roads, we want you to be safe at work, and we really do want you to think very carefully about what your rights are at work. There are some websites you can go to. Fair Work Australia will give you lots of advice. Talking Law with Eugenia, the program was brought to you by Adelaide Hills Toyota.